Go through the terms of the agreement, can go through the finer prints of the agreement, can explain to the client what the implications may be, and assist in understanding certain banking terms. How many average businessmen understand the concept of compound interests as opposed to simple interests? But when the businessman goes to the bank and approval is made, he is anxious to do a drawdown. And if there is default and the accumulation of interest begin, and the bank send out demand notices, and ₦1 million has now suddenly become 2-3 million. Maybe in the interim he has paid about 200,000. He's saying, well, look here, this is absurd. How can it come to this? Are you saying I didn't make any payment at all? But if they understood perfectly the implications of all these terms and the mechanism of the loan transactions, they would be less prone to falling into situations of being bad debtors. The banks themselves, they ought, out of their corporate responsibility to society, engage these parties, whether they are with lawyers or not, to go through with them in a graphical manner. In fact, even have a kind of tutorial, and also making graphical illustrations of the potential pitfalls, and then monitor how the businessman is expending the loan that was advanced to the customer. And then again, I don't want to describe us as a litigious society, but sometimes you can't resist the temptation, really, of going down that road. Take political parties, for instance. In one of the parties, didn't it take them about a year or two to resolve the issue as to who should occupy what position? In circumstances where there are clear provisions, and in circumstances where there are also fallback positions. You know, plan B, if plan A does not work, what is plan B? And it is the belief of many that if there is good faith, all these matters ought not to go to court at all. But you belabor the courts with all sorts of matters. You recall that even political disputes cost the loss of a judicial office holder in office, a otherwise highly respectable judicial officer, lost the job on account of all these political issues. Do you know that the Conservative Party in England, for instance, has been in existence now since about the 17th century, under the name of Tories before they got the name changed to Conservatives. Even the Labour Party, which came after the Tory Party and after the Whigs in England, the Labour Party has been in existence since about the end of the First World War. How many times do you read them going to court to challenge the right of a person to the office of chairman, of secretary, of executive committee? I think really we ought to sit back and consider whether we are being truthful to ourselves, whether there is sufficient good faith amongst us, rather than having to just heap all the blame on the law courts.
With the examples of disputes that you've given, the political cases and the bank cases, how well positioned would you say that the LMDC is to ease the burden on the regular courts?
Well, the LMDC is very reasonably positioned in that we have a list of neutrals, that is mediators, very reputable mediators of various backgrounds. They are drawn not even just from the legal profession. You have engineers, you have accountants, you have people from the various disciplines. And when a matter is sent here from the law courts, we take a look at it and determine which appropriate mediator should be charged with it. You know, it is a way of life which encourages dialogue, a way of life which speaks to the human qualities of using your brain and using all the qualities the Lord has given to you, which is why we are superior to animals. We can reason, and we ought to know the difference between right and wrong. We ought to know when we ought to be able to meet ourselves halfway. You are making a claim for 1 million naira against me, and I say, look, it's only 800,000 naira that is due to you. Now, difference of 200,000. Because of 200,000 naira, will it be wise for you to engage a lawyer who charges you 400,000 naira and to wait for maybe about 2 years when indeed inflation would have dented the amount you are claiming, and when even at the end of the day, if you win, when the defendant can go upstairs to the Court of Appeal, the appeal may be totally worthless, but it's going to take a while because there is congestion as well in the Court of Appeal. There's congestion in the Supreme Court. It may take another maybe 3-4 years before the appeal is thrown out. And then the person, maybe the defendant, also chooses then to go to the Supreme Court. You see, it doesn't really make sense. So if we pause and look at it, we would hesitate gravely before using the law courts as a first port of call for the resolution of disputes. Rather, we would ensure that we exhaust all the available means of resolution, either by arbitration or mediation or some other applicable means.